Good morning, everyone. As the GMAC designated federal officer and temporary chair of the committee, it's my pleasure to call the 16th meeting of the Global Markets Advisory Committee to order. Thanks, everyone, for being here today. We really appreciate it. I'll turn it over to the acting chairman and sponsor of the GMAC, Mark Weegan, for opening remarks.
Thanks, Ted. Thanks, everyone, especially the members, for being here today. We've got a couple of newcomers. Welcome. And a special welcome to our two panelists from abroad, David Bailey and June Mazaguchi. So we really appreciate you two taking the time to come all this way and help us work through some of these issues related to the two topics today. The first being a possible regime for foreign-located clearinghouses, or CCPs. This is something that the staff has been actively working on now for a number of months, and has come very, very close to providing a final recommendation to the Commission for our consideration. And so we're hoping to talk through some of the issues embedded in that proposal today, just to make sure that we have a full understanding of possible consequences and technical things we need to be aware of. And then the second topic is a regime for foreign-based swap trading platforms. And this is something that we've already done some work on at the Commission earlier this year. We had relief for London-based platforms, and I acknowledge again David Bailey, who was very critical in developing that proposal. It contained a considerable amount of input from the FCA. And so we want to follow on that effort with a more fulsome rulemaking and more comprehensive rulemaking in terms of how we should recognize, again, trading venues overseas. So a couple of very important topics. They're important to the overall harmonization efforts of the agency, as well as the harmonization efforts of the other regulators, including our friends in Japan and Great Britain. So with that, again, welcome, and I'll turn it over to Scott O'Malley for his opening remarks.
Thank you, Mr. Chairman. Thank you for calling this meeting to discuss the importance of mutual recognition under the principles of international comedy. Markets and market structure are beginning to evolve in response to the varying regulatory tracks that different jurisdictions are taking in their approach to implementing the G20 OTC derivatives reforms. So in order to avoid shifts in the global swaps market business as a result of the regulatory differences that could impair liquidity and access, it is critically important that international regulators come together in events and forums like this to harmonize swaps data reporting, exchange trading, and counterparty clearing before market fragmentation and contraction of liquidity hardens and becomes permanent. While it is interesting to think about the possibilities afforded by exempt DCOs and exempt CEFs, I believe we need to focus more closely on resolving the regulatory differences between our jurisdictions to enable full substituted compliance or equivalence based on mutual recognition under the principles of international comedy. For example, in comparing a CEF, qualified multilateral trading facility, or possibly an exempt CEF proposal, it is not clear how any of these will provide a solution that is superior to mutual recognition of the existing CEF and MTEF market structures in the US and Europe. Using the QMTEF framework as an example, I fear we are proceeding down a regulatory path that highlights our differences and does not recognize our commonalities. I will ask our panelists and the GMAC representatives to describe what they believe is the ideal regulatory path regarding mutual recognition of US and EU exchange trading rules. With regard to exempt DCOs, I believe that the Commission needs to think carefully before proceeding on such a proposal. This is especially important until we at least have an understanding of the mutual recognition regimes under which jurisdictions will recognize CCPs that meet the standards set forth in the agreed upon principles for financial market infrastructures, particularly since so many jurisdictions have already adopted these standards. Given that the time frame to mandate clearing under EMIR is looming, International regulators need to make progress in this front to avoid further market fragmentation. Finally, let me make my plug, as I do frequently, for harmonization of swaps data reporting. Right now, the U.S. and EU are working separately to resolve data quality issues that we could use the opportunity to work together. And so far, we are not making the necessary steps to set the groundwork for an agreement that would allow our jurisdictions to share this critical swaps data. It is my sincere hope that negotiations will not only begin immediately, but that our jurisdictions will simultaneously engage in harmonization efforts that will allow us to access and share high quality and at low cost the data held by the swap data repositories. In light of the discussion today, I'm reminded of the Path Forward document agreed to in July 2013. And I believe we need to return to the spirit of cooperation embodied in that document before we undertake new and potentially confusing exempt regulatory structures. I certainly appreciate the work of the staff, both as witnesses and our chairman, designate federal officer Ted Serafini, for his efforts to organize this, and I certainly appreciate all of the GMAC members for attending, and certainly our witnesses have come a long way and taken time out of your schedules to participate in this. So thank you very much for your participation today.
Thanks, Scott. Just one quick point. I think I agree with Commissioner O'Malley. We need to come to a mutual recognition approach. Indeed, I think that's what's contemplated here by these staff recommendations on these two rulemakings. The end result of that would be some recognition by the CFTC, and in return, the DCO or the CEF, whatever the case might be, would not have to fully register as a CEF or a DCO under our rulemaking. So I agree. We need to continue with this mutual recognition approach. We've started that last year with a number of different initiatives, including our substitute compliance determinations from late last year, as well as the more recent actions this year. So I think we all agree that's the appropriate way to approach these harmonization issues, and there's a lot of work left before us, and we look forward to the panelists today to help us through that. Thanks.
I know you guys are pros, but quick technology reminder. If you want to talk, you got to press the button. Also, when you're done talking, please turn the microphone off because only a limited number can be on at a certain time. And remember to keep your mobile devices away from the microphone because it might interfere with the sound quality. With that, Mark, would you like to introduce the speakers?
Yeah, again, thank you to June and David for being with us today. We also, for this panel, have Phyllis Dietz, who is with our Division of Clearing and Risk, and I turn over the panelists.
Thank you and good morning. I'm Phyllis Dietz, and I head the Clearing Policy Branch in the Division of Clearing and Risk, and my group is responsible for DCO applications and has taken the lead on the DCO exemption proposed rulemaking. I have a distinct advantage over nearly everyone in this room today because I have actually seen the most current draft of the proposed rulemaking, and you have not. With that in mind, what I would like to do is to go over with you some of the key points of the current draft. It is still a staff draft. It is fairly well developed, but the good news is that this actually ends up being a fortuitous event because we all have the opportunity to get some pre-comments before any public comment period on a published document. The discussion I'm going to give, the overview, again, based on the current document. It has not been approved by the Commission yet. It is not on its way to the Federal Register, and it is subject to change. So I would invite you to provide any and all comments, ask questions. One of my goals for today is to listen and to take into account as we move forward with this process. And what I'd like to do is start with the exemption provision in the Commodity Exchange Act. And you may be familiar with this, but let me just review it for you. The Commission is authorized under Section 5B, paren H of the CEA to exempt conditionally or unconditionally a DCO from registration for the clearing of swaps. So it's not for futures, it's for swaps. If the Commission determines that the DCO is subject to, and here's the important phrase, comparable comprehensive supervision and regulation by the SEC, which we're not dealing with in this rulemaking, or the appropriate government authorities in the home country of the clearing organization. So such conditions may include, and this is explicit in the statute, so it may include, doesn't have to, but it may, but that's always an invitation, may include requiring the DCO to be available for inspection by the Commission and make available all information requested by the Commission. So this sets up the framework for what would be the exempt DCO regulation. The purpose of the regulation is to set forth standards and procedures that would apply to all DCOs interested in becoming exempt. There would also be, at the conclusion of the application process, as with the conclusion of the DCO application process, an order issued by the Commission, so that there would be an order of exemption which could, depending on the facts and circumstances, include additional conditions. But at this point, we have not really given any thought to what those conditions might be. They would be tailored to the individual exempt DCO. So the conditions that I'm going to talk about here today are ones that would apply to any exempt DCO. So just to give you the highest level overview, the way the proposal is organized at this point, there are three basic components. There are eligibility requirements, which will, as I'm sure is no surprise, focus on the CPSS IOSCO principles for financial market infrastructures. There will be conditions, which include certain reporting requirements. And then the last part is procedures, which are going to outline the exemption application process, very similar to the registration process, and then a process for termination of an exemption, either at the initiation of the Commission, because the clearinghouse perhaps is no longer eligible, or at the initiation of the clearinghouse because of a change in business, or perhaps they're going to register as a DCO. The proposal, as it stands now, will also include a proposal for certain conforming amendments for Part 48, which is registered FBOTs, to update it based on the PFMIs and exempt DCOs. Amendments to Part 50 along the same lines, technical conforming amendments. And then it will also include a series of questions about Part 1 and Part 23 relating to obligations of swap dealers and MSPs. But those are matters that are related to the exemption, and today we're going to focus on the exemption draft. Eligibility requirements, we go back to the statutory standard. Comparable comprehensive supervision and regulation by the home country regulator. So the emphasis is on the legal and supervisory framework, not per se what the clearing organization does. But of course, implicit in that is that the clearing organization will be held to and will comply with the regulatory and statutory framework in the home country. So the first requirement, and the eligibility requirements are really pretty compact. The clearing organization has to be organized in a jurisdiction where the home country regulator applies legal requirements consistent with the PFMIs. The clearing organization itself observes the PFMIs and is in good regulatory standing in its home country, and the home country regulator will provide a written representation as to good regulatory standing. Now, that concept has been used with respect to foreign boards of trade and their clearing organizations. We actually propose a definition of what is good regulatory standing, and we can, I think it speaks for itself, but we can, if you want, we'll flag that, we can go back to that, but I'm just going to proceed. So it's PFMI observance, good regulatory standing, and then the clearing organization completes the application form, which is primarily the submission of the PFMI disclosure framework. Another requirement for eligibility, and this really isn't within the control of the clearing organization, but it's very important to us, and that is that there is a memorandum of understanding or similar arrangement between the CFTC and the home country regulator. Because even though the clearing organization is going to be exempt, we still have an interest in the activities of the U.S. persons clearing through that clearing organization. So, and the swaps that are being cleared. So it's very important that we still have an MOU. We always have that when there is a DCO that's registered, and even more important, where we don't have a full window into the operations of the DCO. So those are the eligibility requirements. Then there are conditions, and that's what a lot of people have been talking about and are interested in. So let me go through that quickly. Some are of greater complexity than others. Some people care more about than others, but let's go through all of them. As is no surprise, and I think most people, you've been hearing speeches, you've been reading things, having conversations. There will be a limitation, as it is currently drafted, that there will be no customer clearing. That means proprietary clearing as we define it, U.S. persons, and I'll just paraphrase for you, U.S. clearing members can clear for themselves and for affiliates, anyone that would be listed within our definition of proprietary account. A non-U.S. clearing member can clear for a U.S. affiliate. And then an FCM, just to clarify, a registered FCM, as long as it is clearing proprietary positions only, could also be included. By way of clarification, we are aware of the fact that we define proprietary and customer differently, perhaps, than some other foreign jurisdictions. We are going to apply our definition, and we specifically refer to the proprietary account definition, so that even if an affiliate were a, quote, customer in the foreign jurisdiction, as long as it is within our definition of proprietary, it's proprietary. Second condition would be economic equivalency and non-discriminatory clearing. It's the same provision. It's sometimes referred to as open access. It codifies CEA Section 2H1 capital B, but for easy reference, it's actually incorporated into our regulation for registered DCOs, 39.12, B2, and B3. So you can read that. It's the same provision. Then some administrative matters. The DCO has to consent to jurisdiction in the U.S. and designate an agent for service of process. That's routine. They have to comply with and be able to demonstrate compliance with all the requirements that we're going to apply to them. They have to make documents, books, records, and reports related to their operation as an exempt DCO. So that is constrained, open to inspection by the CFTC. And I would just parenthetically add, one of the goals for the staff in discussing again, potential reporting requirements and other conditions is what is it that we really have a strong supervisory interest in, and what is it that we're just going to have to let go. And so with each of these conditions, a lot of thought has gone into a determination. And there actually were any number of conditions that we ended up not applying because we thought, it's either we're not going to use the information, or is it really necessary, and can this be handled by the home country regulator? So just to give you a little insight into the thought process behind some of these requirements. Okay, so now, digression over. On an annual basis, we would like a recertification by the clearing organization that it complies with the PFMIs, and likewise from the foreign home country regulator that the clearing organization remains in material compliance. There are then going to be some reporting requirements, which actually was the area where there was the greatest discussion about what do we really need and what don't we need. There are general reporting requirements, such as when the Commission asks for information, you provide it. There are daily reporting requirements that we believe are important for our continuing risk surveillance of U.S. clearing members and their affiliates, as well as swaps markets in general, so that on a daily basis, we would want reporting of initial margin requirements and initial margin on deposit for U.S. persons with respect to swaps, and the same for variation payments, U.S. persons with respect to swaps. Quarterly activity reports. These would be following fiscal quarters, information as to U.S. business and what's going on in the marketplace. So the quarterly reports would include aggregate clearing volume of U.S. persons during the fiscal quarter, again, related to swaps, the average open interest of U.S. persons, again, related to swaps, and then a list of U.S. persons and FCMs that are either clearing members or affiliates of a clearing member with respect to the clearing of swaps. And that would actually be one piece of information that probably isn't going to change much. Then there would be event-specific reports. And I would add, for those of you who are familiar with the Part 39 reporting requirements, we're proceeding along the same legal construct. So there's daily, quarterly, annual, and then event-specific. We have many event-specific reports that are required of registered DCOs. We have significantly pared down that list only to those that we really feel are important and that are closely related to our continuing interest in the activities of the exempt DCO. It would be things like change in the home country regulatory regime that are going to be material, an assessment of the exempt DCOs or home country regulators' compliance with the PFMIs, or examination reports. If those become available to the exempt DCO, we would want to see copies of those. Any change with respect to the exempt DCO's licensure or registration, if they've been deregistered. Any default, and this goes to the risk surveillance part, any default by a U.S. person or an FCM, or notice of any disciplinary action that's taken against a U.S. person or an FCM. There would also be swap data reporting requirements, and these requirements, I'll just refer you to some of our recent no action letters, because those outline Part 45 swap data reporting requirements, so we envision something along those lines. In terms of procedure, as I mentioned, there will be an application form. It's not very long. Primary focus is on the disclosure framework. The application is submitted, it's reviewed, and certain parts of it will be made public. And the Commission, there's no time frame for issuing an order, but it is our hope that because of the abbreviated application process, the time frame would be abbreviated as well. There are also provisions for termination, either at the initiation of the commission or at the initiation of the clearing organization, and this is akin to the registered DCO's ability to vacate its registration or the commission's ability to terminate a registration of a registered DCO. So I think that hits on the highlights of what is the current proposal, again, subject to change. We have tried to think of everything. The references I made earlier, Part 48, Part 50, we're trying to think of any other provisions that of our regulations that might be impacted by it. So I would welcome any thoughts that other people have, either not necessarily today, but as part of a future formal comment period, to let us know if there's anything that we haven't thought of. I think we've got the kitchen sink here. So with that, rather than taking questions right now, perhaps I'll just move on to our next panelist. That's okay?
Phyllis, let me just add a couple of other points, if I could. A couple of other key considerations the Commission will have to take into account include general international comedy principles, which is not something specifically mandated by the Commodity Exchange Act, but nonetheless something that the Commission, I think, is cognizant of. I know that's something that Commissioner O'Malley thinks about quite a bit as well. And then the other thing is that the Commodity Exchange Act itself does require that we consider competitiveness impacts of our policymaking. That's something specifically mentioned in the statute itself. And so I think that's another thing that we need to understand and appreciate whenever we make policy. But it seems especially true in this instance, as well as in the case of a regime for offshore trading platforms. So I just want to add those two quick points.
Okay, good morning, everyone, and thank you very much to the acting chairman of the event, and commissioner for inviting the FCA to participate in what promise to be quite important discussions, both with respect to overseas DCOs and CEFs. Before tackling the important questions at hand, I'd just like to get on record the mandate of my own organisation, just so everyone is clear of that, the UK FCA. From a UK perspective, we are the markets regulator. With respect to infrastructure, we are responsible for the supervision of trading venues, but not clearinghouses, which fall within the remit of my colleagues at the Bank of England. However, from an FCA perspective, we do have a very keen interest in clearing-related conduct issues. And in preparing my remarks today, I've collaborated very closely with my colleagues at the Bank of England. So turning to the topic in hand, I thought there's two areas I'd briefly like to cover at a relatively high level. Firstly, I think it's very important we don't lose sight of why we need an exempt DCO or overseas regime for clearinghouses, both from a US perspective, but importantly in other jurisdictions as well. And secondly, I'd just like to give some brief views on how we think that regime should work, which will respond to some of the questions that Phyllis has quite rightly put on the table for us to discuss today. So on the first point, I don't want to give a long reminder to the committee of the important role that derivatives markets play within the broader global economy, but I would focus on the fact that over 50% of that trading takes place on a cross-border basis. And therefore, for that trading, we can't retreat behind national boundaries. Otherwise, business is not going to get done. Risk is not going to get hedged. Effective cross-border access for and to clearinghouses is therefore an essential component of the regulatory architecture that we put in place. But whilst we need to find a way in which firms can interact across borders, we recognise there are risks associated with that. We recognise that financial risk can move quickly through the market and it can flow across borders, and therefore regulators have a real and legitimate interest in business done outside of their direct jurisdiction. So we need to find solutions which meet the G20 mandate from 2009. We need to make sure that systemic risk is managed effectively and that markets are transparent with the appropriate level of transparency both to regulators and to the market as a whole. But importantly, that has to be a shared endeavour. My organisation, I'm sure like the CFTC and the Japanese FSA, we neither have the mandate nor do we have the desire or even the resources to oversee the entire global derivatives market on our own. We therefore need to collaborate to do so in an effective manner. The FSB has long warned about the risks of regulatory overlaps, of conflicts and gaps between our respective rules, especially if different regulators insist their rules apply to the same firms or the same transactions. These aren't speculative issues, they're actually live and practical real issues. Clear conflicts of law exist with respect to the reporting of trades to SDRs or trade repositories in different jurisdictions, and with respect to customer account segregation in the clearing space. In these instances, there's a real risk that firms will be placed in a position where they have to break one set of laws, as they can't meet conflicting legal or regulatory requirements. And that just can't be a good outcome. And that's why the G20, the FSB, and other groups like the OTC Derivatives Regulators Group have all given us the answer as how we can achieve effective cross-border regulation of the swaps and derivatives market, which entails, and I paraphrase, a whole range of reports. It entails avoiding the application of conflicting requirements by deferring to our respective regimes where they provide for equivalent outcomes. This is something that all of the regulatory authorities present have signed up to, and we are committed to working on. And it's fully consistent with the Path Forward document that Commissioner O'Malley mentioned in his introductory remarks that the European Union and the CFTC signed last year. So turning to my second point, how can we make this actually happen in practice? And this requires two steps in my view, which largely overlap with what Phyllis has already introduced. We need an assessment of equivalence or substituted compliance, which is based on an outcomes-based assessment, and we need effective collaboration arrangements between the regulators across the various jurisdictions involved. So taking those 2 points in turn, for an equivalence assessment to be outcomes-based, and that's a phrase that's been bandied around a lot, what does that actually mean in practice? From our perspective, it means performing an assessment at the jurisdiction, not at the individual DCO level, and assessing whether it meets similar standards based on the international benchmark. As Phyllis has already said, that is the CPSS, IOSCO, PFMIs. We should look to those first and over and above as the first port of call. Whilst the PFMIs are extensive, we do recognise there are some areas where perhaps they could have gone into some additional granularity. So it could be envisaged that it's in the mutual interest of the relevant jurisdictions to level up on a small number of key issues and create the same and harmonise on some of the granularity. But any additional conditions should absolutely be kept to a minimum, and they must always be applied at the jurisdiction, not at the firm level. And then the second part of how this regime should work requires excellent collaboration between the relevant regulators so that a host authority can easily access the information. They need to be comfortable that the CCP is being held to the relevant standards. And these were some of the points that Phyllis was talking about earlier. That this is distinctly better than dual supervision or even one supervisor supervising another supervisor. It can be done bilaterally, but we found that it's most effective when all of the relevant authorities get together to share their views on an individual clearing organisation in a college-style arrangement. And that's the mechanisms we've already put in place for the major UK CCPs who clear on a cross-border basis. The approach I've described is broadly consistent with the one that we're following from a European Union perspective. A critical element and it's also the basis on which the UK has operated for many years with our recognised overseas clearinghouse regime, whereby we've allowed overseas clearinghouses, notably a number of US clearinghouses, to operate within the UK, and we have deferred to the oversight of, for example, the CFTC, and we have looked to them as the primary supervisor, and that has worked extremely effectively. A critical element of an overseas regime is having a reciprocal arrangement in place between the relevant regulators. Indeed, from a European perspective, that is enshrined within the EMIR legislative text. And that's why I'm very pleased we'll have the opportunity to discuss the scope of the exempt DCO proposal that Phyllis has outlined today. From our perspective, a regime that applies only to member and not client trades would not be reciprocal, and it wouldn't resolve the issues I've outlined. But I'm confident that these are issues we can work together to overcome. So to conclude, it's clear we need a comprehensive exempt DCO regime based on an equivalence-based assessment and excellent regulatory cooperation and collaboration. Largely, we already have that in place. The building blocks are already there in Dodd-Frank, in EMIR, in the relevant legislation in a number of jurisdictions, and we're keen to work to make it happen. That concludes my remarks, but I'm very much looking forward to questions from the committee later.
Okay, well, thank you. My name is Jun Mizuguchi from FSA Japan. Well, first of all, it's my great honor to be, and also the pleasure to be here with you. And thank you for the acting chairman and also the Commissioner Omarie and the distinguished members from the GMAC. I really thank you for my being invited here. I have just a set of slides, and within just some permitted time, I just would like to take you through these slides very quickly. Before I start, I just want to give some small disclaimer that any views presented here today is just attributed to myself and not to the views of the JFSA. Well. Actually, the David and then also the Phil, they made us some points already, but the various efforts are now currently underway for the international coordination to resolve the cross-border conflicts, inconsistency, gaps, and the duplicative requirements on the OTC derivation, because most of the OTC derivative transaction taking place at the cross-border basis. It really needs international coordination. So the G20, FSB, and also the ODRG, OTC Derivative Regulators Group, which CFTC and also JFSA are the member of. We are working on how to make sure that this international coordination is taking place, and also on a bilateral basis, we are making the progress where appropriate. Then the G20 summit last year at St. Petersburg correctly saying that the jurisdictions should be able to defer to each other when they actually justified by the quality of their respective regulatory enforcement regimes based on similar outcomes in a non-discriminatory way, paying due respect to the home country regulatory regimes. I think this basically a statement was reaffirmed the later G20 ministers and financial ministers and then central governors meeting in February. Then actually ODRG they sent out at end March this year kind of a report to the G20, April G20, outlining the remaining cross-border issues and then the current status and the schedule to how to address it. So ODRG as a whole, we are still addressing any issues and toward sending a final report of to the G20 by November Brisbane summit. Well, when I talk about the cross-border issues on the CCP regulation, actually, I've just cited one example for the Japanese CCPs. Well, actually, under the current circumstances, no single CCP is licensed or registered over both in Japan and the US. For example, the Japanese yen denominated interest rate swaps, for example. So as a result, as a market participant, will not be able to enter into transactions without breaching regulation of either Japan or US, unless CCP, a CCP is licensed or registered in both jurisdictions or exempted in one of the jurisdictions. So that's why a Japanese CCP, Japan Securities Clearing Corporation, is now currently seeking CFTC registration as a US DCO. And then, well, given the lead time needed, the CFTC actually granted the JCC no action relief from DCO registration until the end of this year. Well, then, as Phyllis they mentioned, there are the number of the U.S. requirements currently applicable, or if foreign CCP has been registered as a DCO. Well, it's including financial resources, like sufficient financial resources to cover its exposure, or risk management, or daily, quarterly, annual reporting, as she said, and also record keeping of all the activities on the DCOs, and also subject to the CFTC inspection. Then I just basically cut it just half of it, but well, there's the exemption clause on the CEA, and CFTC may exempt conditionally or unconditionally foreign-based CCP from DCO if CFTC determined that such CCP is subject to the comparable comprehensive supervision and regulation by the home authorities. Then it goes on to say that such condition may include, but not limited to, the requiring DCO is available for inspection, and then also they made available of all information requested by the CFTC. So at this stage, I think further clarity or details will, however, need to be provided. For example, including the condition for granting exemption and the regulatory requirements, which may still be applicable to exempt the DCO. Well, some of the idea and at the staff level has been explained by the Phyllis, but I think the early publication of any consultation document to set out this kind of issue could be very much appreciated, so that to give any clarity or predictability to the markets on this issue. Well, exemption from a DCO registrant, I think there's well, broadly two issues. One is for the assessment method of comparability and comprehensiveness of the home country regime. Then I feel that well, basically international agreed standards like PFMI will be a very useful benchmark. Well, I agree with that, and also the I think flexible and outcome-based approach, taking into account any differences in the regulatory frameworks and the market practices in jurisdiction, because, well, US, Japan, maybe in Europe, we are operating a different market structure, so so-called one-size-fits-all may not be workable in this field. The second broader issue is that whether and what kind of regulatory requirements are still to be applied to exempt DCOs compared with those for DCO registration. I heard from CFT staff's explanation that well, the conditions or regulatory requirements will to be reduced compared with those for the DCO, but we'd like to see well, clearly what kind of regulatory requirements are to be alleviated or to be added in the very near future. Well, then perhaps the possible elements to be considered by the CCP, because CCP is the one who is applying for this exemption if the CFTC rules are finalized. Well, for example, there are maybe two issues: the scope of the permitted business. Well, of course, it's important for the foreign CCPs well, to get to know what kind of scope of business is permitted under the exemption vis-a-vis the permitted business under DCO, because well, the field said it's clearing. Well, the U.S. customers are taking as a client clearing may not be permitted under the exemption. Well, but maybe there might be some other well, the differences in the scope of the business. So it should be made very clear on this. And also requirements still to be applied to the exempt DCO. Well, inspection reporting requirement is clearly stated in the CEA, but further requirements may be applied. So this is also the important consideration for the CCP, whether to apply to the DCOs or exemption. So anyhow, it will depend on how the CCP will judge these benefits and the costs reflect on their business strategy and the models. But in order for the CCP to have a right decision, early publication of this proposal will be very much appreciated. Well, then again, for the regulator side, as the CFTC staff said that, well, it's also very important for the home and host supervisors can collaboratively work on this issue. Well, JFSA, we supervise all the Japanese CCPs and our legislative and regulatory framework of Japan, including our supervisory guideline. So cross-coordination will be really critical for the effective CCP supervision. And actually, in that regard, actually on March 10th, the JFSA and the CFTC established so-called Memorandum of Cooperation for the cross-border regulated entities, including the CCP. So I think that will be paved a very good basis for the further cooperation on this exemption or exempt CCP or DCO registration. Well, basically, this is the fact that I'm just going through from the very few slides, and then I think CFTC is in the process of addressing some of the issues which I just mentioned, and we do hope that we work collectively and in good faith to achieve the common goal. Thank you.
Thanks, June. Thanks, David. Now we're going to open it up for discussion, broader discussion. Phyllis, would you mind taking us through some of the questions that we proposed to the committee?
Before we proceed with some questions about
Phyllis, excuse me,
yeah.
can you pull the mic?
Up, right. Okay. Is that better? Okay. Before we proceed with some of the more detailed questions about eligibility requirements and conditions, I would like to see if anyone would like to comment more broadly on the concept of the exemption. And this is because we have had this authority since the Dodd-Frank Act became effective, 2011, and we haven't issued any exemptions to date. We have engaged in this no-action process, but that has been pending either application approval or registration approval, or now we've been talking a little bit about the possibility of an exemption. So the no-action relief is time-limited and is not viewed, at least at this point, as a permanent resolution. So I just wonder if there are any comments about generally whether or not the exemption proposal is a good idea, bad idea, or let's propose it and see what people think. So are there any just general comments before we get to the specifics? Yes.
Thank you. It's Wally Turbeville from DEMOS. Just on the general tenor of the discussion, Mr. Bailey used the term retreat behind national boundaries, and I was struck by the fact that what he said about it. I'm concerned about retreating behind national boundaries, and I interpret this whole situation completely in the opposite way, I got to say. If you talk to major regulators who are concerned with international regulation right now, the biggest concern they have is that home country regulators in certain places are more and more intent on husbanding information about the financial utilities and also the financial institutions within their boundaries, being concerned that if they share information more broadly, it would harm their home country financial sector. So when I see outcomes-based regulation, that's all about let us husband information and just you concern yourself with the outcomes. And let's remember, this is about registration only. It's about registration. And this is not about registration of a foreign board of trade that just matches transactions. This is about managing the risks of $100 trillion a year swaps market where risk is concentrated in clearing organizations, which if managed well will put us in a better position, but which if managed poorly could be the mechanism for transmitting risk throughout the international markets for another crisis. So this is not trivial. Most of the reporting information is actually, that you discussed, was actually about our institutions that are trading over there. I'm much more concerned about their institutions trading over there and how they're doing and how that might infect our country. So to that extent, I would like to, if I don't get to ask in the future, ask the question whether at a minimum we are requiring stress tests using the test standards that we have developed here, which are extreme but plausible conditions, requiring stress tests for each and every one of the clearinghouses that we're going to subject our economy to the risk of going forward. That's my specific question, but I'd really like to change the tenor of this away from, retreating behind boundaries is all about total comedy as opposed to making sure that we all get the information shared and breaching those boundaries.
If I may just respond to the question about the conditions. These conditions, while similar to those imposed on a registered DCOs, these are conditions that the foreign-based exempt DCO would have to meet. And the concept of holding the clearing organization and its regulator to the PFMIs is that there is comparability. We're not going to find any regulatory regime that is identical to ours because each nation has their own set of regulations, and certainly having been a primary author of our Part 39 requirements, I know that we have some very particular requirements that aren't found elsewhere. But I think we see the PFMIs as being a sufficient standard. We do not have an explicit stress testing requirement. We are not going to look at the margin methodologies under the current proposal because that is going to be left to the home country regulator under the PFMIs. So I think that also raises another question that we had posed, which is, what do people think about the PFMIs as the standard?
Well, you're answering the question by saying we're going to do this, and I'm just so everybody understands. I'm saying that's foolish. We shouldn't do that.
And just to clarify, it is not my intention to say we're going to do this. We are working off of a staff draft now. Ultimately, this is a commission decision. As the acting chairman mentioned earlier, there are certain considerations that are outside of the rule text. Competitive issues, these are the kinds of things. Policy, there are a number of policy decisions that have to be weighed that are wholly aside from whether we want something quarterly or every 6 months. So just to be clear, this is a staff draft, and one of the benefits of this meeting being today is that we have the opportunity to discuss it. So, thank you. I guess, Bob, did you?
Yeah, I'd like to go back to your initial question and say that I think this is a long overdue concept, and one that is actually quite pressing, and it's pressing for a couple of reasons in particular. One is that while the U.S. led the regulatory reform timetable in terms of implementing mandatory clearing, other jurisdictions are rapidly catching up. And there are now mandatory clearing rules either in place or about to be put in place in Europe and in a number of Asian jurisdictions. And when that happens, market participants are going to face the exact kind of clear conflict that we talked about at the beginning. In other words, if you have a U.S. participant trading with a non-U.S. participant, each one of which is subject to a mandatory clearing determination, and each one of which is subject to clear in a clearinghouse regulated by their home jurisdiction, there really aren't a lot of choices you have. Either one of those parties can decide to break the law, which isn't going to happen, or they won't do the transaction, which I think is unfortunate. or we're going to have to find a way of providing mutual recognition of clearinghouses so that both parties can clear the trades at a clearinghouse of their choice. The second thing that I think is worth mentioning in terms of how critical this is that it's been widely reported that the Commission is now considering a mandatory clearing determination for FX NDFs. That hasn't happened yet, but if the press reports are accurate, it's certainly under active consideration. And I think the NDF market is largely dominated by local transactions involving potentially cross-border counterparties who provide liquidity. And if they're subject to a mandatory clearing determination in the U.S., unless there is a comparability or recognition regime in place, I think the kind of conflicts that we've talked about and that exist potentially already are going to be exacerbated. I'd also like to go back and respond to some of the comments from my fellow committee member. I think that the Commission and its foreign colleagues are quite capable of sharing information. They do it routinely. They do it in the enforcement context. They do it in other contexts. And I think you can work out the details of that information sharing. I think what's more troubling is what appears to be the premise behind the remarks, which is that there's U.S. regulation and there is inadequate regulation. I think that's a false premise to begin with. I think there are multiple regulatory regimes. We have a number of participants in the G20 standards. I think they're all working in good faith to implement those standards. And I think in order to achieve the policy directives behind those standards of fostering clearing of what is a global market, it's going to require a lot more coordination among regulators in order to make it work in a seamless manner.
Let me just make one point of clarification on the, just for the sake of the group and discussion on the issue of the NDF mandate. It's probably most accurate to say that's being actively recommended to the Commission, but we're still mulling it over.
David?
So I would, in answer to your question, Phyllis, I represent LCH ClearNet, and we are, I don't want to say unique, but we have been and are duly regulated both by the CFTC and the Bank of England, that is to say LCH ClearNet Limited. So we have experience in a dual registered environment. In answer to Phyllis's question, I would commend your initiative here. I think also, as Rob has just said, it is long overdue. We feel that the PFMIs are a good basis for which to make these determinations. We think that the dual registration has been challenging, and while it works and has certain benefits, the notion of an exempt DCO category is one that has merit, the details of which need to be worked out between the regulators. We would also agree with the concept of the MOU, as you've articulated, in terms of the standards of inspection, record keeping, reporting to the SDR, and open access. And so our comment would be very supportive of the initiative that you've outlined.
Kim?
Thanks, Phyllis, and I want to thank Chairman Weejan and Commissioner O'Malley for holding this forum and letting us have an opportunity to participate today. In answer to your question, I think, and speaking on behalf of the largest major exchange and clearinghouse that has to date primarily located its business in the U.S. regime. It gives me a certain perspective that I want to share. I think CME broadly supports the idea of mutual recognition with a level playing field. It needs to be thoughtfully considered, though, for all of its implications. Needs to be grounded in the PFMIs. I agree with several of the parties who've talked about that. And it needs to limit the exporting of what I would call PFMI gold plating across jurisdictions. So now let me describe what I see in the current environment. In the current environment, with respect to futures, the CFTC has long granted and has persisted with basically complete relief from regulating foreign markets and foreign clearing of those products, of foreign futures products by U.S. persons. That has been done with various types of exemptive relief, and those have stayed in place over time, and including in the post-Dodd-Frank arena. Now, if I look at what's happening in Europe, I'm quite familiar with what I'll call the quest for European equivalence as a clearinghouse, as a clearinghouse, and in some respects, the quest for European equivalence has many of the elements of what I would call a financial doomsday thriller. The European authorities have taken hostage basically all of the exchanges and clearinghouses that do not operate on their soil, and said that as of a certain time, those hostages will basically be shot. With respect to on December 15th, if there's not an equivalence determination, the European parties will not be able to use markets or clearinghouses that exist outside of European soil unless equivalence has been determined. And the way that equivalence is being determined, it involves the exporting of a fair number of elements of European regulation. To take Bob's comment and turn it kind of on its side, it's almost as if the EU authorities are determining that there's European regulation and ineffective regulation. So the same comment could be used from either direction. So what I would like to see is an opportunity for the global regulators to work together in a way that is not time limited by a big doomsday clock ticking off the time until December 15th, and come to an agreement on a mutual recognition regime that allows for a level playing field across multiple jurisdictions.
Thank you. I would preface my remarks by just picking up on something Kim said there, and I think we should stress the importance to have a global level playing field. So what I'm about to say, I would say to Europe and Asia also. But turning to the opening this morning, I was encouraged to hear both, at the outset, both commissioners refer to the importance of mutual recognition, and then further remarks by Commissioner Wiegand calling for the need for comity and competitiveness. And for me, as outlined by Commissioner O'Malley and echoed by Mr. Bailey, I think that has to take the form of a full substituted compliance or equivalence route. So it's disappointing that the staff proposal refers to the exemption at an entity level rather than a jurisdictional level. A second, and based on this initial take of the proposal, a second fundamental issue that jumps out is that the proposal for exemption is limited to interbank clearing and not client clearing. And I'm not sure that provides any relief. We're very close to the entire interbank market being cleared already, particularly in rates and credit. And that market seems to be functioning pretty well within the existing frameworks and has done for a number of years ahead of any regulatory mandates. And I think client clearing is where the relief is needed, not interbank clearing. I think the approach, if adopted, will lead to increased or prolonged fragmentation and less choice for US end users.
Again, let me start by saying thank you for having us here. I work in the Singapore Exchange, and we are, I think, the only Asian clearinghouse that is a registered DCO. And so we've been through the hoops on registering. And while that was interesting, it didn't quite solve our problem. So let me kind of step back to say why. I think that the object of the Singapore Exchange trying to have our clearinghouse registered was to be able to continue to clear US customer swaps, which are done between US entities and Asian counterparts. And in the context where we are a registered DCO, the issue just goes one level lower in the sense that you need to have FCMs as members. And today, in the context in which we operate, in most of our jurisdictions, the membership that we have are not the exact FCM entity of all the client organizations. So you have an equivalent affiliate, which is a general clearing member, generally subject to local regulations, and is generally a part of the locally incorporated entities. And in the context where the GCMs are doing the clearing, it is still not possible for them to clear US customer positions. And again, speaking broadly, most of our members don't see the business rationale yet to have two memberships, one for clearing non-US business and one for clearing US business. And our hope, of course, is that there would be a route through the affiliate model, as in the futures markets, to do the similar thing on swaps. Now, again, if you step one further level into the detail, the core really seems to be about affording bankruptcy protection under US regulation to the US customer base. And I think that that is something that one could work solutions for. But I think that it certainly doesn't stop at this level of a debate. I think that we could easily agree to having recognized clearinghouses overseas. But if it doesn't extend down to being able to clear US client positions, then it doesn't quite solve the problem in its entirety. So I think it's important to bear that in mind as you deliberate the processes as you go forward. To me, the registration or not and being recognized house, the difference is not great. In both cases, you have to do all the data sharing. You do have equivalence in many contexts, and PFMI does provide a fairly good basis. However, it doesn't have, address, as example, the US bankruptcy or different countries' bankruptcy laws. So it's in peeling the layers that I think you will need to kind of spend more time and attention.
Ramu, a special thanks to you for being here today. You've come all the way from Singapore. We appreciate everyone attending, but you've made a special effort given the distance you've traveled.
Thank you. Yeah.
And nice to have your unique perspective as a foreign-based registered DCO.
Thank you.
Adam?
Can I just say one other thing, too? I couldn't agree more with Ramu. In a lot of ways, at the heart of this is a country's bankruptcy regime, and what we as regulators here at the CFTC have to say about that, and what interests we have in terms of, if I can use the word, protecting the U.S. customer in that way, because I think we've all seen in recent times how the regimes work differently in our space, in the derivative space, and referring obviously to the MF Global situation. And for a variety of different reasons, the customers of the MF Global FCM, they have commitments to have all their monies returned, and that has happened in a relatively quick amount of time. And I'm not sure where the proceeding is in London. I've lost track, but my understanding is hasn't gone quite as quickly, at least. And so that is something we're thinking a lot about. In fact, just this morning, we had a rather lengthy discussion about it, Phyllis and I and some others, and it came up in the context of an earlier discussion we had with some of David's colleagues in Europe about both the equivalency determinations as well as related FCM, SEG, bankruptcy issues. So that does seem to be, in a lot of ways, at the heart of this, but it's a very important consideration, I think, to make. And so I imagine that notwithstanding some of the complications it creates, I guess I would ask the group to appreciate what our interests as regulators are in the sense of making sure U.S. customers trading in our regulated venues and through our regulated clearinghouses have the full benefit of appropriate bankruptcy protection.
Go ahead, David.
Acting Chairman Whedon, just to come in on that point. Clearly, from a European perspective, as we are going through the process of authorising clearinghouses under EMIR to operate across Europe, we're having to deal with exactly the issue you've highlighted there of different insolvency and bankruptcy rules in different jurisdictions. And a critical element that we have found is ensuring the legal enforceability of the CCP's default rules in each of the jurisdictions that it operates. So a primary focus has been to ensure that if a clearinghouse is going to operate in more than one European jurisdiction, we have the CCP is able to give us very clear comfort that its default rules are fully enforceable in those jurisdictions, which will facilitate its ability to handle a default and return client monies. So that's been a primary focus. I think that, to a large extent, if we have that in place as part of an exempt and overseas regime, that will address a significant amount of the concerns that you've raised there.
If I may just add for a moment, and then we'll hear from Adam, just by way of background, this commission has never issued an exemption that permits 4D segregated funds to be held in an account other than a 4D account. We came close to that with respect to Singapore. It was no action relief that permitted limited customer clearing for the period of time until they became registered. So I just wanted to point that out, that as a policy matter, it would not be impossible to do, but it would be a major, major change in the policy of this commission, and it would be given very careful consideration. Thank you. Okay, Adam.
Thank you very much, and Acting Chair and Commissioner O'Malley and Designated Federal Officer Serafini, thank you. I want to address a few things, but I think that last point you raised is critical, Phyllis. One of the key aspects you ask, are the proposed eligibility requirements appropriate? And one of the key aspects of the PFMIs is the requirement of fair and open access to the clearing infrastructure. Citadel believes the proper implementation of that principle is essential to the proper implementation of swap markets reforms. So we urge that the regulations be sensitive to the concept of fair and open access and provide or permit, if you will, as little daylight as possible between the CFTC's regulatory position on impartial access and the approach taken by the local regulator. But that fair and open access really is kind of the crux of what we're talking about. And I commend David Bailey's point in his introduction that we should not separate the customer solution from the proprietary solution. So in thinking about whether an exempt DCO should be permitted to clear swaps for customers that are U.S. persons, we have to recognize another critical component to swaps market reform is customer protection. Certainly, the discretionary authority granted to the CFTC shouldn't be exercised if the result would be a result that would place the U.S. customers at a disadvantage to the regime they would have here in the U.S. And so that's really the challenge here. I think there is a solution. I think we're pretty much in agreement that there's a path forward, and perhaps the way to navigate that path is that the Commission should establish a route whereby an exempt DCO would be permitted to clear swaps for customers that are U.S. persons if there's some sort of fundamental demonstration that the outcome of its customer asset protection regime offers a level of protection that's at least as strong as in the U.S. And I think David a moment ago talked about the legal opinions or the assurances that can be given. I think that that may be a way to sort of navigate this path, so we provide the fair and open access to customers and not just the proprietary solution, but assure that the U.S. Participants are not disadvantaged.
So I think the follow-up question then is, should that assessment of another regime's customer protection approach involve issues or rules or laws outside of our very particular responsibilities here? In other words, should it include an assessment of another country's bankruptcy approach, which is not something that either we have a direct say in, or even the FCA has a direct say in, as I understand it, in the UK. Is that an appropriate thing for us as policymakers to consider?
To consider, but not necessarily mandate, right? I think it goes into the equation of the comparability assessment that needs to be made in the process of the exemptive, relief exercise. So we're not seeking to legislate the foreign country's bankruptcy regime, but we have to make an assessment in light of the requirements that exist here in the U.S., whether it's comparable and sufficient.
So then just to clarify, the suggestion would be that an applicant for exemption, if they wanted to clear for customers, what we consider customers, they would have to make a demonstration, provide exhibits, documentation, legal opinions, whatever, analyzing a comparison of the U.S. and the home country bankruptcy laws, and then it would be up to the commission to make a judgment as to whether or not there was comparability, because the PFMIs don't address bankruptcy. So I just want to make sure I understand.
Yeah.
Okay, thank you. Kim.
Just another type of issue that I think we need to make sure that is considered in looking at the bankruptcy implications would be the implications of a large portion of the dollar-based swap business or the dollar-based FX business clearing in a location that is outside the jurisdiction or oversight of the U.S. authorities in a broad sense, not just in the narrow sense of the CFTC supervision of the exempt DCO, but in terms of the impact, the potential impact to the broader U.S. Financial industry or the economy at large of the liquidation or the crisis management impact of a large default situation that was done without U.S. oversight. I know that a lot of international regulators have also had that as a concern.
I just wanted to build upon those comments about the issue of the application of bankruptcy or insolvency rules more generally as it relates to client business. It strikes me that it fundamentally is the elephant in the room here, because what we're talking about in terms of the clearing mandate is not really the interdealer market at all. The interdealer market has been substantially cleared now for a number of years. A series of commitments made as early as 2005 signaled a significant migration towards interdealer clearing of business. So when we're talking about clearing, whether under Title VII, under EMIR, first and foremost, we're really fundamentally talking about client business. That introduces the difficult topic of what does that mean in terms of risk allocation and the impact on customers in the event of a CCP default or a member default. Inevitably, that's going to raise fundamental tricky questions which go beyond the conventional purview of the CFTC in terms of looking at considerations of insolvency law. But I do think that that really is what this is all about. And the consequence of not going down that route and grasping that nettle is that we get increased numbers of tangible examples of conflict and potential for market fragmentation. Early indications of which, as have already been suggested, are not theoretical, but are real. We've seen it in the context of trade reporting. We're seeing it now in the context of individual account segregation requirements. And if we roll forward to the regulations that are still to come down the track, either here in the United States or in Europe or, quite frankly, elsewhere, that potential for conflict in the absence of a genuine and concerted outcomes-based approach to the consideration of alternative regulatory regimes is going to lead to increased instances of market fragmentation. I think if that means that the focus of the CFTC has to encompass within its scope allocation of risk in the circumstances of CCP failure, and picking up on the point that David mentioned from the FCA, then I think that's the route that has to be adopted. Otherwise, I appreciate it will be very difficult for the CFTC to get over the line in terms of satisfying itself that customers are not at risk. But as I say, a focus of this effort exclusively around the interdealer business strikes me fundamentally misses the point.
If I may, I'd like to yield the floor to an invited guest, Bob Wasserman, who's our bankruptcy guy. That's, I think, his title. So he's the chief counsel of the Division of Clearing and Risk.
Thank you, and thank you all. Thank you to you all for letting me interrupt us for a few moments here. With respect to the PFMI, I think we have a wonderful opportunity here because we have a standard that's been agreed to internationally among the regulators. There is a structure for evaluating and essentially assessing compliance with that standard that is going on even now among the various jurisdictions to see essentially, are folks in fact observing those standards? With respect to bankruptcy regimes, that's a much more difficult task. There is no agreed standard in terms of bankruptcy or customer protection. Some folks have mentioned, well, perhaps we could get opinions. I will tell you that my experience in getting law firms to actually give opinions as opposed to memoranda with respect to issues in general and bankruptcy in particular has been that it's like pulling teeth without anesthesia. To get them to give opinions that actually are essentially pin folks down as opposed to say, well, if this happens, maybe, and if that happens, maybe, I think would be a very heroic task. And so those are some of the difficulties I see. I would also note that when we're speaking of customer protection, it is not only at the level of what's at the CCP, and thankfully we've seen very few instances of CCP failure or loss of customer funds at that level, but rather we are also concerned with the potential loss of customer funds at the intermediary level. And so those are just some of the complications that would be involved if we were to start trying to assess bankruptcy regimes. Thank you.
And Bob would be the person who would have to assess them. Okay. Let's see.
That's Commissioner O'Malley.
Thank you. David, so I'm clear, can you lay out where you said about the customer clearing regimes and requirements, how the U.S. is incomparable at this point, and what would it take to be comparable? I'd also like to hear from Mr. Mizuguchi whether Japan is seeking customer client clearing in its application, and then maybe Phyllis can respond, or Bob can respond now, that how our LSOC proposal for swaps meets, kind of responds to whatever David's going to say.
Sure. So, and just to one point Bob made earlier about getting a legal opinion on bankruptcy laws, that kind of reaction is actually pretty much what I get whenever I try and get a legal opinion on anything, let alone bankruptcy. But Commissioner O'Malley, to your point, so from a European perspective, as we've been authorising clearinghouses in EMEA, and I'm talking specifically here to start with about European CCPs. We have, clearly they're operating in a number of, could be operating in a number of European jurisdictions, and therefore what we've really focused on through the college arrangements that we have in place for that authorization is, can the CCP effectively deploy its default rules? As I'm sure you're aware, one of the structures available to under EMIR is the individual segregated account, and under that account, one of the key benefits of that type of account is, in the case of the insolvency of a clearing member, as opposed to the CCP itself, the CCP can return the client's positions and the client collateral directly back to the client without going through the clearing member's estate. That provides, from our perspective, a really effective way of ensuring that that client can either transfer those positions to another clearing member or take whatever action they seem they feel is relevant. The important thing is their collateral and their positions are not tied up in the clearing member's account as it goes through administration, and that's the sort of maximum level of protection afforded to a European client under EMIR, and they can elect to take on that protection. So a key focus from a regulatory...
Can I, sorry, sure. But so you have to assess all the individual European countries' bankruptcy regime as to whether or not that bankruptcy regime would permit what you just described?
We are not. So from a regulatory perspective, the onus is on the clearinghouse to demonstrate that it can effect its default rules legally in each of the jurisdictions it wants to operate in. That's different from assessing each clearinghouse against all 28 countries, because not every clearinghouse wants to operate in all 28 countries. That is it's primarily assessment from the CCP, and the obligation is on the clearinghouse to demonstrate to us that it can affect its default rules. Commissioner Malia's secondary point was on the comparability from a US perspective and the US equivalence assessment. And that is a process, just to be clear, that is a process that is being coordinated by ESMA and the European Commission. And I can't speak on their behalf as to the current status of that assessment, nor would I want to. But essentially, part of that process is assessing an overseas regime. Not is it identical to the absolute letter of every sentence of the law, but does it provide for broadly equivalent outcomes, i.e. is there a mechanism to get client funds returned to them in a timely manner and allow them to continue with their business? So again, I'd very much stress we are not assessing as regulators the bankruptcy or insolvency legislation in other jurisdictions. It's for the clearinghouse to demonstrate to us that it can affect its default rules.
If I may just make a comment on this, the issue with a place where the customer has to make the choice of whether they go for this ultimately segregated account results in a lot of customers not making that choice up front. And therefore, you end up with customers who have commingled margins and therefore the inability to unwind this quickly. So in some ways, it's not, inappropriate to think of a regime that would almost mandate customer funds to be in segregated accounts. And what that does in many cases then is levels the playing field everywhere. And you do have, house margins and customer margins are mandated to be individually segregated. And that's, again, something to think about, because I think that is the issue, if you go through the past occurrences in the European context, that's what made them, they're all in omnibus accounts where they are not segregated by customer. While they're broadly segregated into customer and house, they're not individually segregated. And therefore, that is something that, you could almost look at as a condition for equivalence, or at least afford that to the US customer base, and then the rest can still have it optional if that's what they want to do. Ultimately, when it comes to margins are generally higher if you are individually segregated. And in most cases, they say, it's not worth the difference. You kind of become mingled. And then when the times are not good, it looks bad in retrospect, right? So I think that's really the fundamental assessment that has to be made about, is it worthwhile to mandate that or not?
Just to add on that, and thank you very much, Acting Chairman and Commissioner O'Malley, for a chance to weigh in on these big considerations. Just a follow-up to that point, I think, though, that still individual segregation, albeit might be a very good idea, still doesn't, to my knowledge, solve the bankruptcy issue that we have in the states, which is ultimately that in the event of a bankruptcy, that ultimately all customer assets would be pooled and distributed as per the administrator. And so ultimately that's another way to perhaps further protection, but doesn't actually get at the underlying conflict of bankruptcy issues.
I think that a lot of this discussion is, as I think, pointing to the fact that this is a very worthy goal, having a level playing field and a mutual recognition regime, but that it is a process that will have many impact points and needs to be thoughtfully considered for all of those impact points. And I think the global regulators need to work together to try and achieve it in a way that does not unnecessarily drive up the costs for everyone using the broader derivatives trading and clearing system. although the idea about individual segregation as a mandate certainly has aspects to it that are tempting, I think that it is also an example of a situation where, as Emily points out, there might not be an ability in certain jurisdictions to actually achieve it, or it might be mandating a significantly higher cost on the vast majority of market participants who would not actually choose to quote unquote buy that additional insurance. So I think the discussion points to the fact that it seems there's wide agreement that we need to pursue a mutual recognition regime that applies globally, but there are a lot of issues to be worked out, and it's probably not something to be done hastily and without a lot of consideration of all those implications.
If I can just make a couple quick points. Certainly, Kim, in response to your concluding remark there, one of the benefits of a meeting like this and ultimately of a public comment period is to take the discussion to the broader public with more specific details and be able to consider some of these very critical issues, some of which mark a dramatic change from the way business has been done in the past. Also, I believe Commissioner Amalia asked about customer clearing for our own clearinghouses, and JSCC has an application before us, and it includes customer clearing. And for all of our registered DCOs, we require that they have the ability to offer customer clearing. If they don't have any customers or FCMs, so be it, but they have to have the capability to do that as full service.
Well, thank you. Just for the Japanese regimes, well, on the segregation portability requirements, basically we are conforming to the PFMI principles. Well, some of the accounts, some of the CCP are taking some individual accounts for some products like OTC derivative products, but we are basically in conforming with the PFMI. Well, one of the difficulties we are facing here is that, the Japanese CCPs are either being assessed by the European regime and also they're being assessed by the US regime. So what would happen that, unless EU and the US are conforming each other, we are in a very difficult position because once we are meeting the criteria of the one particular party, that may not guarantee that we will conform to another party. So that's quite a dilemma that we are facing now.
Can I ask one question? The bankruptcy point was made about how it squares with an individual segregation approach here in the United States, or how it doesn't. But if someone from representing an FCM are familiar with how they operate, isn't it in fact the case that it is possible to set up some kind of an individual segregated account? It'd have to be funded by the FCM in some way, as I understand it. But if someone would be willing to talk about that a little bit. In other words, I've heard from, I know at least one FCM that it is in fact a possibility. It might be a rather expensive one, but I wonder if someone from the FCM committee could speak to that.
I can talk to that if you like. We certainly can set up individual segregated accounts for our customers, and there could be a cost associated with doing that in terms of funding as well as operational support. But I think the real issue when you get down to just pure customer protection is in the event of my FCM's bankruptcy. At the end of the day, those any assets held in any customer account, segregated or not, would be deemed a part of the overall customer pool of assets to be administered by the estate. So a customer having opted into individual seg has no real more protection in the event of my bankruptcy as a customer who was in my omnibus seg account.
But isn't there a way to work around that as well, to give them some other status as a creditor in the case of bankruptcy?
We have not figured that out yet. From my understanding is really no.
Yeah,
I mean, even a third-party custodial account would be the exact same thing. They which are not allowed in futures, could be allowed in swaps, but same thing. It would be part of the pooled assets in the event of of our bankruptcy.
Yeah, I'll second that from a FCM perspective. I think the issue really is it's costly. You're likely going to want to pass the costs on to the client, and the client is going to say, okay, this is very expensive. Now I want your assurance that in an insolvency, I'm actually getting better protection out of this, and you just can't give them that insurance because at the end of the day, the 4D pool and the 37 pool get administered as a pool, and customers share pro rata in the loss.
Yeah, the difficulty there is that the bankruptcy code has that provision which provides for pro rata distribution. And so even though you keep it in a separate pool, so long as you are in fact a customer of the FCM, as opposed to a direct clearing member, you would be essentially prorated in the event of the insolvency of the FCM, which is why we developed LSOC basically as a way to harmonize a degree of individual customer protection, but on the other hand, dealing with bankruptcy code.
Bob, building on that LSOC question, and it was part of the question I asked David, since the swap rules mandate we offer LSOC, if we offered customer clearing as part of the exempt DCO proposal, would we have to insist that we too offer LSOC for that as well, and therefore European clearinghouses would kind of face the same challenge as U.S. clearinghouses under European rules?
Well, the difficulty is that in order to get the bankruptcy protection under the U.S. law, you have to be going through an FCM and to a registered DCO. And so that's why that would not be practical with an exempt DCO. With respect to the FCM issue, the approach we've taken to this point, including with actually LCH for many, many years, has been essentially they have a two-strand approach. And so, in other words, they have FCM members, that is to say, registered with us, who would clear for U.S. customers, who would then get the U.S. bankruptcy protection, as well as anyone else who wants to come into the FCM. They have what I think they refer to as SCM, swap clear members, and those are direct members of LCH Limited, and they are not registered with us. They clear for non-U.S. customers, and they would then be resolved or liquidated under the appropriate local law. So that's the approach we've taken to sort of harmonize those things. I guess my concern, I would note one other point. I do realize that there is the requirement that the CCP, as I understand in Europe, the CCP then does an assessment that its rules, including the bankruptcy provisions, can be essentially are reliable under local law. The concern I guess I would have, while speaking from a personal perspective, it's great to have that work done elsewhere, that the difficulty in actually reliably getting that assurance, in other words, trying to get, for instance, the opinions that I think we're agreed are very difficult to get out of lawyers, would simply be passed down to the CCP, and we would then be faced with, I think, ultimately, either requiring the CCP to do that, which may not be able to be done, or essentially accepting something that the CCP does that says, well, here's the best we can do in the way of legal assurance, and having to accept that. And so that's where it really does get sort of complicated, I guess, from my perspective.
Just a quick comment. Go ahead. I'm sorry.
So I just wanted to come in on that, just that direct point, and just to note that from a European perspective, we, as we've been going through the EMIR reauthorization process for European CCPs, we have managed to get that level of reassurance. Obviously, we haven't looked at it from a US perspective, but we have managed to get that reassurance from CCPs and their legal advisors that they are able to operate their default rules. Otherwise, we wouldn't be in a position to be reauthorizing European CCPs.
Just wanted to make a comment and then ask a question of the staff if I can. I mean, the comment is I'd like to echo what others have said about how important it is to solve for client clearing, but I also think there is a benefit in solving for house clearing because we've actually seen instances where a U.S. participant transacting outside the U.S. with a non-U.S. counterparty had an available clearinghouse, wanted to clear the trade, and was unable to do so because the clearinghouse said, we're not a registered DCO and we don't want to register. So, there is an incremental benefit in doing that. I guess the question I have for the staff is, if you turn the pages of your own rule book, there are actually two existing models for how to handle customer funds for customers clearing outside the U.S. Under Part 30. One model is that if a jurisdiction or a firm has I forget whether it's 30.2 or 30.4 exemption, the client can deal directly with a foreign intermediary and place its money with the foreign intermediary for clearance outside the U.S. And as part of that comparability determination, I think, in fact, the staff does look at the customer protection regime of the relevant authority. So that's one model. And the other model is under 30.7, if a customer chooses to clear through an FCM, the FCM will hold the funds under a 30.7 protection regime and then use a foreign intermediary to clear for its client account. And I guess my question is the staff not looking at those precedents because you feel you're unable to because of the way Title VII is drafted, or do you feel that as a policy matter they're just not good examples?
Well, I think basically it's because those are dealing with futures. Part 30 deals with foreign futures, and swaps are neither domestic nor foreign as they're defined under our regulation. So I think we view swaps, or at least have up to this point viewed swaps differently from futures that are traded on a foreign exchange. Bob, do you have anything to add?
I think that's right. And I think that essentially the foreign futures are just that, foreign futures. And then when you're having a swap involving a U.S. counterparty, it's, I think, a bit more difficult to characterize that as foreign in quite the same way.
Yeah, it was mentioned earlier in commenting on my earlier remarks that implicit was that belief that there was U.S. regulation and then worse regulation everywhere else. And I certainly believe there's U.S. regulation and different regulation everywhere else. And it can be better or worse. But one thing that is apparent from this conversation, which is very consistent with my experience, I was honored to spend 5 years with Goldman Sachs in London working with your predecessors. And so I have a certain appreciation for how things are done in Europe. And in discussing, my experience has been in talking about, for instance, just taking it for example, some clarity issues. Clarity in the area of bankruptcy is often greater under U.S. law than if you have to deal with 28 jurisdictions plus the EU on top of it, with many different layers of EU-ish on top of that. And that's different. Is it a better way of going forward? I like France. I like Germany. But it's undoubtedly almost definitionally more complex and less transparent and clear in terms of outcomes of law and outcomes of regulation. So I would like to, could you comment on that? Is forgetting what the outcomes are, is it or is it not generally clearer when you're dealing with outcomes as compared with if you have to deal with a more complex situation? Take, for instance, the EU and the member countries.
I would, certainly the experience I've had in bankruptcies is that things tend to work a bit more cleanly the less complex they are. I will say that my nightmare has been waking up and basically having a judge say, when we're trying to get customers moved and trying to get money moved in that first day or two after a bankruptcy, and we've arranged for a transfer, and having the judge say, well, somebody's raised a very interesting and complex issue, and let's set up a briefing schedule. Because what we have seen under U.S. law has been, even in a case like MF Global, where customers had definitely not gotten all that they were due when it was due to them, was the ability to transfer substantial amounts and do so very, very quickly and very, very efficiently. And I think while others have noted there are some very real concerns about the pro rata approach, and I think with the addition of LSOC, does make it very practicable to transfer on a bulk basis and do so very efficiently, and that's been the experience. And I'm not sure experience elsewhere has been quite as smooth.
So I agree with many of the comments that have been made about the importance of customer clearing being the key issue here. And I would just love to return for a couple of minutes to the point that was made a few minutes ago, which I thought was excellent about Part 30 and the futures model. And I guess for me, I wouldn't be so quick to dismiss the relevance because they're swaps, not futures. I think the issue of customers seeking access in non-dollar markets is actually quite similar. And I think that, these are such complex issues that the power of having certain models in place that have been tested and have worked in futures shouldn't be underestimated. And I think that looking to the Part 30 model is, would be a very, very good exercise.
For what it's worth, that was actually the exact same point I was going to make. I think we're trying to solve for so many different things here, and right now, what you have is that U.S. persons, obviously cannot clear in a foreign market unless they are that market is registered as a DCO, or there's this exemption process. So I think we all agree that having a framework around the exemption process is a clear, very important for the path forward. But secondarily, as we're pointing out, that still wouldn't solve for the issue that every U.S. person must interact through or must transact through a U.S. FCM. The Part 30 process would actually allow an intermediary, which again would be a much more efficient process, and I think very futures-like. And I think there are a lot of benefits, and the model is already there to allow that. So I would encourage the Commission to truly think about that. And then as far as customer assets and segregation, again, taking even then a step further to think about the 30.7 account class and having some similar type of account model for swaps perhaps. But I think there is a roadmap that, yes, it absolutely pertains to futures right now, but one that certainly could be informative as we look to solve very similar issues.
And again, we have looked at that and considered that, but we're happy to, in light of the comments today, go back and revisit that. Yes.
Is one of the considerations that would have to be part of that determination, though, to use 30.7, the fact that I think the Commission has taken care to isolate the futures customers from the risks that come from the swaps trading. And so I would think that would occur if you blended it into the 30.7 unless you went with a similar parallel structure.
Yeah. It would have to be a parallel structure, and among the things we have discussed internally is whether or not, if you were going to go ahead with customer clearing, if you'd actually have to have a new account class, because we've just done a rulemaking that said in 30.7 that's only for foreign futures and options. We used to be able to put OTC transactions, positions in there, and that's no longer the case. So there is legal engineering that would have to take place, and we would have to kind of walk through that and in a very detailed way if that's the path that we want to take. Again, while none of these things is perhaps impossible, the fact is I would not dismiss the distinction between foreign futures and swaps. The legal construct that we're talking about here is that when you have the sufficient nexus with a U.S. person, we regulate the execution and clearing of that product. And there is no legal disagreement that we don't regulate foreign futures. So there is an additional legal hurdle, and again, maybe it's just a matter of engineering, but we're not dealing with exactly the same thing. So there is a level of complexity that, you know, we are aware of, and as a policy matter, if we go down that path, well, we'll just deal with the complexity. Yes.
So, you know, when we're looking at which DCOs, CCPs to join and which markets to invest in, we'll look at it across, you know, three different dimensions. One is like the liquidity pools that are available, customer asset protection, as well as, especially in the swaps world, any type of new operational risk that may be introduced. And you know, as we're having these discussions, the complexity of separating out U.S. person customers from certain DCOs versus others, it just adds a level of complexity that on the buy side is somewhat difficult to be able to execute again. So I'd just like to consider that. The other thing is that there will be certain DCOs which may not be U.S. based, may not want to register in the U.S., but have the maximum amount of liquidity, maybe in different time zones. So we may be disadvantaging U.S. person or U.S. customers by putting in a policy or a rule that does not allow customer clearing through those DCOs. So that's just, you know, if you could take that as a point of consideration. And then, you know, as we're talking about the segregation models, you know, if these DCOs were to offer full segregation, you know, maybe that could be taken as a point of consideration to be somewhat similar to LSOC. David, I know that that doesn't address your concern, you know, the other way around. But, you know, as we're thinking about this exemption, if we could just take that as a consideration around the customer clearing element.
Suparna, you mentioned that you look at this in three dimensions, one of them being the customer protection afforded in a particular jurisdiction or trading venue. So I presume that has to involve some assessment of the bankruptcy protections. But to what degree does your analysis include that? And how does that relate to assessments about costs around individual seg? So help me understand that a little bit better.
I mean, so when we look at, you know, customer protection, there could be, you know, elements that are within our investment management agreements that may not allow any type of, you know, cross-border. So that would just, you know, for U.S. person, I think we've, you know, we've shared that for certain CCPs, you know, we can only use them if they're U.S. registered, you know, DCOs. From a bankruptcy regime perspective, if you had individual seg for certain type of our investment vehicles, you know, it would be the pension plans or what have you, regardless of cost, you know, that may be the preferred choice. And then, you know, for the rest of, you know, the segregated models, we work very closely with Bob Wasserman on LSOC, and we felt relatively comfortable that the amount of protection as well as, you know, the oversight that, you know, both the Commission as well as BlackRock would have from an oversight perspective, we felt pretty comfortable looking at that as an alternative on providing, you know, the right level of asset protection as well as operational efficiency. In Europe, we don't have that available, and, you know, to some extent, you know, that's a little bit of a roadblock for us to move forward because, you know, you have LSOC, you have individual seg, and you have Omni, but it's not clear that the, you know, that the individual seg is being offered in an efficient manner.
So it's the operational challenges that you're running into when you're looking at whether or not to avail yourselves of individual seg in jurisdictions like Europe.
Yes, you know, and I mean, obviously, you know, we don't have the mandate, you know, in play right now. So we are taking our time to make sure that we are considering, you know, all the three elements that I mentioned. And ours would be, it's not only the CCP level, because, as a customer and user, we obviously access the CCP through an FCM or an SCM. So we have to look at it, through both sets of flow.
Because I think this operational challenge issue is something that probably informs one of the other considerations we have to make in deciding what to do here, and that again is considerations about competitiveness. And so we need to think through what kind of an effect would making an exemption or providing relief there, will that have in terms of how one clearinghouse competes with the other. And it sounds like this operational challenge is a significant one that people need to think about, at least on the buy side.
But also the liquidity component is important, because if you eliminate or you restrict a U.S. person customer from being able to clear, in these DCOs, I think that could be a disadvantage, or at least to the U.S. customer. In the event also, where you may have a majority of available liquidity in one of these foreign DCOs that choose not to register.
I think these last remarks are a nice segue into one final topic as I see the clock ticking, and this circles back to something that the acting chairman mentioned at the very beginning, and that is concerns about competition and the impact that the proposal, as I have outlined for you today, has on competition as between really any market participants, between clearinghouses, registered clearinghouses, exempt clearinghouses, duly registered clearinghouses, clients, customers. And if anyone has any, I've taken some notes on particular disadvantages here and there, but if anyone has any particular remarks they'd like to share about competition of any type as a result of the proposal as it stands now. Kim?
Yep. My competition concern is not so much directly related to any specific element of the proposal. My competition concern is related to the fact that in listening to the discussion about such a proposal, or the broader discussion about mutual recognition across jurisdictions and perhaps even globally, so that customers and intermediaries and clearinghouses and intermediaries can serve customers in various ways, which I think is a good goal. That to me is feeling like it is not something that is going to be definitively solved in the very short term. And the serious competitive issue that is in place right now and live and active right now for all exchanges and clearinghouses that are not located on European soil is the fact that on December 15th, European persons will no longer be able to trade or clear futures outside of European soil without having them treated like bilateral swaps, and the regulatory capital requirements just explode. That is a serious competitive issue, and it is something, the lack of certainty around that is already starting to have an effect on end customers' decision-making around where they might want to trade, where they might want to clear. And my concern is that there's been kind of no discussion about trying to solve for that part of the problem on a faster path than solving the broad global mutual recognition regime. And particularly, I would like to reiterate the case for the fact that the CFTC, with all of the various types of Part 30 exemptions, has a very hands-off approach to the trading of futures and clearing of futures by U.S. customers in foreign jurisdictions, and there's no move to have a corresponding acknowledgement of that coming the other way from Europe in a time frame that is not going to be harmful to not only, this is an issue that affects not only U.S. exchanges and clearinghouses. It affects exchanges and clearinghouses in every jurisdiction that is not in the EU.
Yeah, I would echo Kim's comments that the uncertainty around this can create more harm then, because it's been a series of, I guess, the deadline being extended every time you get close to the deadline, right? So now either people have assumed that it'll always keep getting extended, and if it doesn't get extended for whatever reason, you'll have a calamitous few days in terms of people adjusting to the fact that it didn't get extended. So that's one worry. And the second worry about this is, of course, by making it extremely complex for persons of U.S. persons to access overseas trading capabilities, what happens over time is that you will have unnatural concentrations of risk in one or two clearinghouses in time zones that are far away from where the risk needs to be managed in the case of an event. So you would have, not market operating times during which you're going to have to deal with issues that are, again, you have pretty large positions that will build up over time. I think the relative sizes of the capital markets between the US and Europe and, let's say, Asia, it's pretty clear that if segregation were to happen as, it can in a worst case, you would have concentrations of Asian exposures lying in Europe and in the US, which will not be able to react because of the time zone differences, and that itself will have outcomes which are not quite desirable. So those are the two issues that one worries about in complexity. And I think, again, the point that Emily and you made earlier about looking for parallels which have worked has a lot of appeal and is something that people will be able to adjust to and work with easier than any other kind of solution.
I would, to Rama's point and to Kim's point, you'd be interested to know it's 142 days from today that the European clearing mandate, or the determination of December 15th on European clearing determination of U.S. CCPs is required. Whether we have a exempt DCO with customer clearing or not customer clearing, we're simply run out of time. We need to proceed, kind of in expeditious fashion to harmonize our rules at this point and figure out what it's going to take to make sure that we can get the recognition for not only the U.S., but whether it's going to be Singapore or Japan or the other entities that are seeking recognition that have met the PFMIs. I think it's a time then we need to set some dates between our governments to sit down and hammer out these issues, because the proposals and getting comment and redrafting and considering, we don't have enough time to address this and to get the outcomes that we're hoping to achieve or that we've all considered. And I think if the staff recommendation is a member clearing only, there's a lot of concerns about that. I think we need to refocus our efforts on harmonizing our rules. And David, that's pointed at us and pointed at you. If you could take that message back, that it's name the time and the place, we'll be there.
So just on that, Commissioner O'Malley, I would agree, and I don't think we should leave the committee members around the table underestimating the amount of discussions that are taking place between the regulators to get to a harmonised and sensible position. There's been more collaboration over the last 24 to 36 months on these markets than I've ever seen before. I think that's positive, and that gives me comfort that that we can get to a sensible place in the time frame that we need to.
Let me just add, based on a discussion this morning, I think there's a willingness to resolve this certainly before December 15th. That's my impression. Whether we get there remains to be seen, but I think that's certainly a shared goal. With that, we should probably, I'll turn it over to Ted to tell us to break for lunch.
Well, we can break for lunch now, but there are two more comments if you guys want to make it. Stephen.
Yeah, sorry, I'll be very quick. So just one response on the competition question. Two barriers that the proposal seems to erect, I think, are the fact that foreign DCOs will continue to find it hard to access US clients. Maybe that's the intent, but I don't think that's consistent with G20 and FSB goals to avoid fragmentation. And the second barrier is that US clients will find it potentially hard to transact with with foreign DCOs. So it's both sides of that coin. But then a sort of technical question, going back to what I said earlier, the entity versus jurisdiction approach, I'd be quite interested to hear, Phyllis, why you went down that road. And I'm thinking partly because the statute provides the exemption route in the CEA. And then a question for Acting Chairman Wiegand. You mentioned competitiveness being in the statute also. Does that give you some wiggle room to go more towards a jurisdictional than an entity approach?
In response to your comments, first of all, while I think we are aware of the competitive issues related to, and we have, grappled with the customer clearing, no customer clearing issue, there is always an alternative, and that is for a foreign-based DCO to register. And then the whole customer clearing issue goes away. We do have Singapore Exchange, LCH, 2 LCHs. We have ICE Clear Europe, and even the Natural Gas Exchange in Canada, though some people don't think that's foreign, but it is. So the U.S. is a jurisdiction that permits clearinghouses that are not organized in the United States to register and be fully registered. So I also don't want to lose the perspective of that. But, we're all for efficiency in the markets. I don't need duplicative regulation. I got enough regulation. I, work long enough hours. So I think we all have the same goals, but let's not lose sight of it's not a matter of either I get customer business from the clearinghouse's perspective. Either I have customer business or I don't. Well, if you register, you can have it. The other thing, in terms of looking at the individual clearinghouse versus just the structure, while the statute is written in terms of the regulatory framework, we do think it's important to look at the individual clearinghouse to get these certifications from the home country regulator, to look at their assessment, to make sure that indeed it's not just the framework, but it's actually the clearinghouse that is, and this is an eligibility requirement, that is actually complying. And so that's the only reason, we've done it that way, because we see it as twofold and as an analog to our registration process. Let's look at the individual entity. But I would say in terms of the, application process, which would be individualized, it's basically the disclosure framework. So it's not that in itself is not a heavy lift.
But on the theme of avoiding double regulation, David's already done all that homework. So for you to go in again and do the similar stuff, isn't that a double burden?
Well, we're not actually doing the same thing. The disclosure framework's already been developed. There's already a regulatory scheme, and to a great extent, we are relying on the home country regulators' oversight and their certification. So I think that the continuing, like the reporting obligations, those are the kinds of things that we feel we need to discharge our responsibility for our own market oversight. So it's not so much that daily reporting of margin on deposit is not supervisory in nature. It's to help us look at the clearing member. They also operate in the U.S. markets, and to help us understand the risk profile of entities that we may regulate and that have a significant impact on our markets. So
Phyllis,
we're not the supervisor.
Can I ask a question? Do we send people out for exempt DCOs, or those are operating under no action relief? Will we send CFTC staff to inspect books and records, or are we just simply relying on reports?
Yes and no. We want to have authority to do that if it is necessary, but it is the staff expectation and I'll say staff very carefully, it's the staff expectation that we will not make routine on-site visits. And
Routine or house calls?
Well, on-site visits at all. I mean, we have a full plate,
More than a full plate.
more than a full plate, visiting and overseeing the clearinghouses that are fully registered with us. So I think while we want to have the ability to do it, I don't envision that because I don't know whose staff is going to do it. So I think the answer to your question as a practical matter is no.
Well, I mean, but if we're to Stephen's point and to David's point, if they're doing the job, when do we give up the job and rely on their regulatory? I mean, we haven't been that brave in terms of substitute compliance thus far. However, and maybe if Gary Barnett is here, will we be sending people to inspect swap dealers overseas currently? These are the same entities we've given substituted compliance. I'm just a little concerned about how thin we're going to be stretched if we insist on double checking the regulators we've given substituted compliance to.
Well, I would make a fine legal distinction between substituted compliance and an exemption. Substituted compliance meaning you're required to comply with our laws and rules, but we're going to allow compliance with this other regime to substitute for that. That's not what this exemption is about. The exemption is you would be subject to our regime, but we're giving you a pass with these certain conditions. And we are largely relying on the other regulator. I mean, that's one of the fundamental premises. Somebody else is doing this job. We're going to allow them to do it. But we do not, as envisioned by the staff, give up 100% responsibility for everything. But as a practical matter, we're not going to go visit them. We would sooner terminate the exemption. If we think that, and this is the staff's vision, if this clearinghouse is in trouble, and we talk to the regulator under our MOU or similar arrangements, and they say, yeah, they are in trouble, we can terminate the exemption, and we're done. We're not going to work with them. We're not going to examine them. We're not going to issue an examination report. We don't review their rules when they're filed. You know, they're not really on our bus, but they sort of are. And we have a continuing interest in a way that is very, very minimal compared to what we would do for a registered DCO.
Sorry, and I guess I didn't phrase my question I was trying to raise before, entity versus jurisdiction, probably was better phrased. Why exemption rather than full substitute compliance?
And I think it's basically because that's how we read the statute. And to the extent that U.S. persons trading swaps are within our jurisdiction, we would exempt them from the requirements that would otherwise be imposed. So the statutory language is exemption. So that's why we have stuck to it in terms of the legal construct. I think, though, as a practical matter, I'm not sure that at the end of the day there's any real difference, because it's really the home country regulator that is going to be supervising this entity. And the fact that we get information or a certification once a year, or they tell us if there's been a clearing member default of a U.S. clearing member doing swaps business, that doesn't make us the supervisor. And my own view is I don't consider the CFTC to be the supervisor or even secondary supervisor of an exempt DCO. They're exempt from our requirements, except for certain conditions that we're going to impose, which are permitted under our statute. So I think that's how we're reading the law.
And Stephen, just to give you if what you're concerned about is kind of a fairness issue, why the CFTC is imposing it on a clearinghouse and somebody else might not be, I can give you our experience with the European jurisdiction. It's a two-step process. There is an equivalence determination that's made at the European level, and then there is an individual clearinghouse process of review that is. Our submission to ESMA for this review amounted to thousands of pages of documentation. So it certainly is not a situation where going one way, it's a free pass, and going the other way, it is a you have to submit your PFMI compliance report. The regime in Europe is a two-step, and actually the second step, the clearinghouse specific step, is much more onerous than the process that Phyllis is describing.
Mark, did you want to say anything?
Stephen, I'd love to answer your question, but we're overdue for lunch.
Chris, the crowd looks a little eager to get out of here, but would you like to close us out with any remaining comment?
Okay, I should be very brief then. I was just going to make two very brief points. First is, I think in relation to the contemplation of any client-related business, I think that possibly limits quite fundamentally going forward the capacity for dual registration to be the solution, because I think those fundamental conflicts associated with account segregation, whether it's Article 39 under EMIR and the interaction with the various elements of the US Bankruptcy Code, I mean, I think the prospect for client activity of relying on dual registration is a short-lived solution. The second point, which is just to pick up on a point that Kim made relating to the European perspective for the recognition of non-EU CCPs, I would just like to reiterate that to the extent that there is any obstacle in terms of the satisfactory resolution of that dialogue between the CFTC and the European Commission, which may have its origin in any kind of miscommunication regarding what the Europeans are looking to see from the CFTC, I would very much encourage that doubt be removed as soon as possible, because whilst we have just seen the deadline pushed back to December in terms of fundamentally what is going to be the regulatory capital consequence of that determination landing poorly, it was originally set for this June, and the period between now and December, of course, is quite short. More fundamentally, the deadline is not really December because firms and institutions need to know the direction of travel well ahead of December 15. The consequences from a regulatory capital perspective, as Kim alluded to, are not trivial. They're absolutely devastating in terms of the impact on the market if that dialogue is not resolved successfully. Thanks.
With that, thank you, Phyllis, for presenting. Thank you, Bob Wasserman, for also joining the conversation. We'll break for lunch and reconvene at 1:30. There's lunch available for the GMAC members upstairs also.